नमस्कार, मैं एडवोकेट अभिषेक रंजन सिंह केस नंबर 9 के साथ आपके समक्ष प्रस्तुत हुआ हूँ and I hope you will be able to comprehend whatever I have been giving or coming out with these videos. And as I have stated, these first 10 videos will be on the disability jurisprudence of the military pension. And as we move forward, these cases are the leading cases which decide about the disability or the different aspects of disability of the military disability jurisprudence. And I am on my case number 9, and I would like to state that when we come to the case number 10, it will not be the case number 10, but the video number 10 will sum up all the 9 cases and the nitty-gritties of the defense pensions. What are the aspects which you should know when you go about in a case which involves a disability pension, the war element of the pension, the service element of the pension, and what are the regulations on the rules which are applicable to the military pension. As a son of an air warrior, I have seen these issues quite closely for the last 35 years, and I hope I'm able to justify all this through these videos. They are not very exhaustive because I know uh, because there are various aspects which we need to go about while deciding a case. And while coming up with these videos, sometimes I have to read whole file which is of 150 200 pages to sum up in 10 minutes 15 minutes. It is very difficult, but I have tried my best to keep it simple so that you are aware or somewhat aware that what goes behind deciding the cases. I hope I'm able to justify myself and able to give something concrete to you. So, moving on, case number 9, Union of India versus Captain MP Singh and others. Let's go. जब हम इस केस में आते हैं तो वॉर एलिमेंट का आपको यहाँ पे वर्णन मिलेगा. So what happened in this case? Union of India versus Captain MP Singh and others is a short 2005 Supreme Court order dismissing a batch of appeals filed by Union of India against orders of High Court of Punjab and Haryana that had upheld the grant of disability, war injury pension and its broad banding to ex-servicemen. Reiterating the now settled law, the court held that where no disease or disability is noted at the time of entry into the armed forces, the presumption of sound physical and medical condition arises, so that any disability leading to a subsequent medical discharge is presumed to be attributable to military service unless the employer reverts the presumption following Dharamveer Singh, Rajveer Singh and Vijender Singh. The court further reaffirmed on the authority of Ram Avatar Vijender Singh that the benefit of rounding off of the disability element cannot be denied. Now, what this mean? This means that now it is a well settled in law that अगर आप ज्वाइन करते समय आपके मेडिकल रिकॉर्ड में कोई ऐसी एडवर्स एंट्री नहीं है रिगार्डिंग योर फिजिकल एंड मेडिकल हेल्थ, देन इफ एनीथिंग happens to you after you have joined the armed forces, that then it will be presumed, it will be assumed that it is because of the service or attributable to service or it has been aggravated by the service. तो ये जजमेंट बेसिकली सम अप कर रहा है कि जो डिसेबिलिटी है वो अगर आपको ज्वाइन करते समय नहीं हुई थी, दैट इज वेल सेटल्ड इन गिरीश कुमार आल्सो एरियस के केस में, और वहां यहाँ पे भी वो कह रहा है. So there was a bench of appeals filed by the Union of India against the cases of Punjab and Haryana courts in the Supreme Court of India. So it involved the issues of ex-servicemen. There were few appeals filed by the ex-servicemen and they were granted relief by the Punjab and Haryana High Court that was appealed by the Union of India in the Supreme Court. Now, the arguments of the Union of India was that disability disease was not attributable to or aggravated by military service, and therefore disability war injury pension ought not to have been granted. वो बोलते हैं कि बिकॉज इन इसके कारण नहीं हुआ है सर्विस के कारण, तो it should not have been granted. The benefit of rounding off or broad banding of the disability element was wrongly extended to the respondents. So it is also well settled, like we have discussed in the earlier cases, that the broad banding which was done in the year 2001 should be applicable to all the cases, which was not done in these four bench petition. What the respondents said: the since the respondents were found medically fit at the entry with no disease noted, the presumption of soundness operated and the disability manifested during the service and leading to the medical discharge was presumed attributable to military service, the burden of rebuttal lying on the union. So it is on the employer, in this case the Union of India, that you have to prove that it was not attributable to or aggravated by the service conditions. So the entitlement of rounding off or broadbanding of disability element was no longer res integra. That means it has already been settled. That is, it is judgment in rem. So it is not questionable. It is being settled by Ram Avatar versus and the Vijender Singh. The benefit could not be denied. So the judgment, which is very important, and I will read judgment line by line. Disability pension is available to army personnel in Dharamveer Singh versus Union of India 2013, which was followed in Union of India and others versus Rajbir Singh, and recently in Vijender Singh versus Union of India. The law has been settled that in absence of disability or disease noted or recorded at time of entry into the armed forces, a presumption of sound physical and mental condition would arise, and on the basis thereof, in the event of subsequent discharge on medical ground, deterioration in health shall be presumed due to military service, and therefore his entitlement to claim disability pension would arise unless presumption that disability was neither attributable to nor aggravated by military service is refuted. Following the Fifth Pay Commission, the recommendation by a circular enhanced benefits came to be available to those who were invalidated out of service due to serious service injuries after 1/1/1996. On this footing, later courts have recorded placing reliance on Ram Avatar and Vijayendra Singh to hold that benefit of rounding off of the disability element could not be denied. The court found no merit in the union appeal and dismissed. So this case settled the question of rounding off, the areas, the broadbanding. So, Union of India versus Captain MP Singh and others clarifies, and there is no doubt that the rounding of broadbanding or the areas have been settled in Ram Avatar and Vijayendra Singh, so the benefit will be given to the ex-service men who have been invalidated out or who have superannuated or who have done their part of the service of 20 years or 15 years, that is, they have served for the engagement for which they were recruited. So these 9 cases which I have discussed in these 9 days sums up more or less the disability aspect of military jurisprudence, और कहीं ना कहीं बहुत क्लियरली बताता है कि जब आप डिसेबिलिटी की बात करेंगे तो रेगुलेशन 173 की बात करेंगे, रेगुलेशन 183 ऑफ द पेंशंस रेगुलेशन एक्ट की बात करेंगे, 1963, 1988, द आर्मी एक्ट, द एयरफोर्स एक्ट एंड द नेवी एक्ट, जहां पे भी रूल्स एज पर एप्लीकेबल होंगे. और एक चीज मैं बहुत क्लैरिफाई कर दूं इन चीजों में कि ये तो एक लीडिंग केसेस थे, इनके ये बेसिस हो सकते हैं दूसरी केसेस के, बट हर केस अपने आप में एक नया केस होता है. तो जैसे हम बता रहे हैं कि एट्रीब्यूटेबल टू एग्रीवेटेड बाय, नाउ एवरी केस इज डिफरेंट. सपोज समबडी इज ओबीज एंड ही गोज टू द मेडिकल बोर्ड और वहां बोलता है बिकॉज ऑफ दिस आई हैड दिस ओबेसिटी, obviously it will be rejected. Now again it depends ki why that obesity, the reason for the disability should be given by the medical board, the invalidated medical board, the resurvey medical board. So it is a complex thing, depends on case to case basis, but it is a very large area which cannot be summed up in 9 videos. Obviously I have simplified it, I've given to it so that you become informed. So while going to the courts you are aware कि more or less किस तरीके से हमें एक एस्पेक्ट में जाना है. Government of India makes sure that all your rights, you get all your rights are in time, your pension in time, disability pension, war element pension in time, but again it depends on case to case basis. And uh, the service which you have done towards the motherland is taken into consideration. And I hope you have enjoyed watching these videos, and it has made you much more informed than when we started. And I'll cover next set of videos जो कोर्ट मार्शल पे होगा, दो जो कोर्ट मार्शल के निटी ग्रिटीज होते हैं उस पे होगा. So I hope you have enjoyed. The next video will be on, I will sum up all these 9 things in one video, and what are the papers which you should keep while going to the courts in case of a disability pension. अगर आप जा रहे होते लेने तो कौन से पेपर्स आपके पास होने चाहिए, एंड थोड़ी बहुत और एडिशन में करूंगा. So that will be video number 10, and which will sum up the disability component of these 60 videos. And next we will start with the court martial and the other aspects of it. Jai Hind.